Okay, everybody, welcome back. We're in week 13 already, which means next week we're going to have our team meetings, and you guys are going to impress the heck out of Dr. Levinsky and I on your legal knowledge. But before we get there, just like talk just a little bit about last week's contracts, which I hope you found to be a bit of fun and relaxing activity. It wasn't really stressful, but I think everybody kind of looked at their contract and said, okay, I'm comfortable with this. And you could see where there were a couple of places where they could cause you grief. A number of people didn't put a start date. And if you don't put a start date, but you say the work needs to be completed in 4 weeks, 5 weeks, whatever, then that person can say, okay, great, give me your deposit, and I'm going to start 6 months from now. And if they don't agree, if you had it in your severability section that they don't agree to sever the contract, then you could be waiting 6 months for safe front stairs. There was one student who had jurisdiction as the state of Pennsylvania, which there's nothing wrong with that. I mean, that was perfectly acceptable answer. There's no question. However, on something this small, right? If you had to sue the person for the $1,000 back or $1,050 back, the deposit back, and they happen to or they want to sue you, they could file in Philly if you live in Pittsburgh. There's nothing wrong with that. It's in the state of Pennsylvania. They are meeting the agreed terms on jurisdiction. So, when you have the opportunity to write the paper, you always put it in your terms. Now, what does this have at all to do with security work? Well, a whole lot of stuff that you do as a security manager is going to be done by contract. Most security managers, and I will stress that security managers in the government realm as well. If you're in Homeland Security, you will use a lot of contractors for intel services, for guard services on buildings that you may have to set up physical security for all kinds of things. You're going to need contracts with these people, and understanding those basic sections of a contract that we went over for our project on the stairs, hopefully that will remind you that those sections are also applicable in service contracts for security work. So applying them to the stairs hopefully will make you more successful when you apply them to things that are closer to our business. Now let's get started talking about legal authority of security workers. And in particular this week I want to concentrate on off-duty police officers as security workers because it is a common practice. It's getting even more common. And there are some advantages and there are some pitfalls, and I think it's worth spending the week talking about this and going over some cases on it so that you understand if you make that decision in your future employ that you're well informed and you know what could come back to bite you. Let me start with a quote from the reading this week, so you'll see this again. And it's, unfortunately, the law is not always kind to those who are, in their judgment, trying to do the best thing or the right thing based on an emergency or threat situation. And in that statement, it's basically telling you that no matter your motivation and your reasoning when you make a decision in the security game, in an emergency or in a threat situation, you still can be second-guessed on it. You're going to make that decision potentially in a few seconds, and someone else is going to spend years picking it apart. So understanding what could go wrong up front maybe gives you pause during those few seconds that you have to make a decision to say, no, stop, maybe not. I'm not trying to make anybody hesitant on decisions, but just understanding that you're going to make a decision in a very short amount of time and somebody else is going to spend a lifetime picking it apart potentially if they think there's money in it should give you pause to try to understand things that could go right and wrong with that decision before you ever have to make it. So when we talk about the legal authority of security workers, you'll make decisions on who will be your security workers. As a security management person, in my security management course, we talk a little bit about contracted versus proprietary security officers, right? Those are two different animals in a lot of ways. But from the standpoint of security personnel and legal authority, we're normally talking about uniformed security guards. We're talking about armed security guards, non-uniformed security guards, and even if they're contracted. We're talking about proprietary security managers, supervisors, generally those who are directly employed by a company or a venue. We have a category called special police and security police that is not common in every jurisdiction, but is becoming more and more common, and we'll go over that this week. And then we have the whole issue of using off-duty police, oftentimes in their uniforms and using their vehicles and using their service weapons for security purposes under a private contract. So when we talk about that legal authority, there are limits and there are challenges. We're going to talk a little bit about arrest powers and detention. Detention being one that is really problematic in the security realm. We normally don't make arrests as security officers, but you'll see where we could. But detention is something that is relatively common, especially in retail. If you're chasing shoplifters, you've got to make a decision on detention or not detention very quickly before the person leaves the venue. We'll talk a little bit about the impact of uniforms and structure and how that may impact legal liability. The attitude of the security officer / police officer / special police in general will oftentimes open you to liability, and that's really a training issue. And then there are gray areas, and the courts have pretty much applied something that I'll call the duck test. In fact, there is something called the duck test, and you all are familiar with it. And the court really has applied in every case that I've read on this particular subject, and I have read lots of them on this subject because it is just something that interests me, right? Off-duty police as security officers and retired police as security managers is something that interests me. And the duck test is something the court almost always applies. They may not call it that, but that's exactly what it is. Let's talk generally about arrest powers. And there are some nuances to this in certain jurisdictions, but generally speaking, this particular description applies. A police officer can arrest a person when the police officer has reasonable cause to believe the person has committed a public offense, or when he has an arrest warrant. So that makes perfect sense. A police officer comes to a bar fight and sees you, with bloody knuckles, and sees somebody else on the ground with a broken jaw. And people around say, yep, Brian's the one who hit him in the jaw. Police officer, arrest me. I've committed a public offense, right? Assault and battery, which we know what that means now, right? Or if there's an arrest warrant for me, they can pick me up on an arrest warrant. Now, a citizen can also arrest someone. You as a citizen can arrest somebody, and everybody's heard the term citizen arrest. And you can arrest somebody if you reasonably suspect of committing a felony. Now, a felony, by definition, is a crime that is in law identified as a felony and can normally the sentence for which is more than 1 year in prison. Less than 1 year in jail is normally a misdemeanor. More than 1 year in prison is generally a felony. There are circuit court misdemeanors which have a little bit different twist to them, but they're an exception. So just, everybody kind of knows what a felony is, the serious charges, right? So a citizen can make a felony arrest, even if the felony didn't occur in their presence, right? So if I see somebody running out of my neighbor's home, I hear gunshots, and I jump up and I run outside, and I see somebody running, and they see me, and they drop their weapon on the ground, and they stop because they're kind of in shock, I can say, you are under arrest for possession of a firearm, because I know that to be true, right? If I look in the house and I see my neighbor is laying on the floor bleeding out, then you are under arrest for homicide. I can say that. I have reasonable suspicion that the person committed a felony. I can make that arrest. Now, why I would do that rather than detain them in some way and ask the police to do it, it's beyond me. I'm not sure why citizens ever do that, but there could be some reason. Now, a security officer has the same arrest authority as the citizen, not as the police officer. But they don't lose that citizen arrest power when they put on their security uniform or when they go to work if they're in a security leadership position. So it's the same as they don't lose any rights. They just keep the same citizen rights. Now, as long as the felony was actually committed and the individual that made the arrest knew that the crime was committed, had a reasonable suspicion, they're pretty much protected from any tort action having to do with a false arrest, right? That was the person running out. I saw them drop the gun. I saw my neighbor through the window bleeding out, and I detained them and arrested them as a citizen. If I find out that they were actually someone who was working in the home and they were actually running from the person with the gun who went out the back door, or they picked it up and they ran with it, whatever, and I was wrong, I'm still pretty insulated because it's a reasonable suspicion. Hearing a gunshot, seeing somebody bleeding out, seeing somebody running from the scene, reasonable suspicion, right? But if the crime did not happen, then the person making the arrest could become civilly and criminally liable. And that is more likely in a citizen's arrest than in a police arrest. It is very hard to sue police departments, as we know, right? They have some sovereign immunity. In general, people can't use a citizen's arrest for misdemeanors unless it's considered a breach of peace. And a breach of peace is generally a list of minor offenses, but that you can make a citizen's arrest for, but I'm not sure why you would. So if we look down this list of breach of peace items, fighting or challenging someone to fight in a public place, using offensive words in a public place, shouting in a public place, bullying a student on school grounds, shouting profanities at a car window in front of a person's home over an extended period of time. I mean, these are things that someone would probably be arrested for. And a security officer may be the first person to encounter these kinds of things. If you look at things like intentionally playing loud music during the night that continues even after a fair warning, many apartment complexes have nighttime security. And the security officer could go and warn somebody about their loud music because a neighbor called and complained. And they could go back a second time and do it. And on the third time, they could make a citizen's arrest for a breach of peace. It would be something they could legally do. Now, the big question is why? If you as a private citizen, if you were the guy next door with the loud music, went and knocked on your neighbor's door and said, hey, can you turn that down? I'm trying to sleep. Yeah. Half hour later, it's loud again. You go knocking and say, come on, man, turn the thing down, will you? Third time you knock on the door, first off, you probably wouldn't knock the third time. You'd just call the police. But if you went and knocked on the third time, you wouldn't look the person in the face and say, you are under arrest, my friend. Okay? It doesn't really work that way in real life, and it shouldn't work that way in security life either. And so for those types of breach of peace incidents, even though a security officer may be more likely than the average citizen to run into many of these types of incidents, like somebody knocking loudly on hotel doors of sleeping guests with the purpose of annoying them, hotel security would likely come across that. No real citizen would normally do an arrest, so why would a security person? You simply call the police. Now, what I'm saying to you is common sense, and you are all very smart people. I've come to understand that over the last 13 weeks. And so you get all that. But some security managers have cut to the chase when it comes to these types of incidents, especially the breach of peace type ones. And they hire off-duty police officers to be their security, to add teeth to their program. That's really what they're looking to do. They're looking to make it when an off-duty police officer knocks on your apartment door and says you need to turn the music down, you normally will turn the music down. He's there in his uniform with his service weapon. Right? He's working independently under contract to the apartment complex, not as part of the police department. But normally you will do that. And there's a lot of ways that that security managers do this, right? They contract sometimes through the police agency itself. More common with small town police departments. If you need somebody for traffic control because you're going to have your company picnic on your grounds, right? You're going to have 1,000 people show up and there's going to be limited parking and there's going to be traffic backed up. You may call the local police department and say, hey, can I get traffic control for a day? And they'll say, absolutely. But it won't be an on-duty police officer. You will pay a fee for that and they will send you a bill and you will get an off-duty officer in the police car with his uniform. You won't be able to tell, but they will be off-duty and paid under contract. Now, oftentimes the police unions in larger cities will do this. City of Pittsburgh, for instance, if you call and you say, I'd like to have, a police officer present for, college football game at Pitt, college football game at Slippery Rock. If Slippery Rock Borough Police Department, if the university didn't have their own police, they may contract with the county sheriff or the borough police. A lot of times police departments want to stay out of this. So they leave this they leave it open that it is allowed to moonlight, but you need to do it through a security company. And a lot of times the security company is just a shell company for a particular police department or a number of police departments. But there are security companies that specialize in providing off-duty police officers in uniform to you for certain purposes. You can use on-duty police as part of special details I have one facility where I need to, there's an irradiator, right? We use radiation in order to treat certain pharmaceutical products for purity. And when the radiation tubes need to be changed out, we need to shut down a section of highway. We use on-duty police as part of a special detail on that. The city doesn't charge us normally for that activity because it's well planned in advance, and it's working with DOE and others, state highway departments. So they generally just take it on the chin, but that's pretty rare. On-duty police, if you're asking for special details, you're normally going to pay for it, and it's normally going to be off-duty. And then there's the application for special police or security police officers, where this is allowed by law. There's kind of a middle ground between a security officer and a police officer in several states, and I'll talk about the exception in Pennsylvania and a bigger one in Michigan, where I live, where you can actually have police powers assigned to a venue as opposed to a police department. So you're probably thinking, the security industry is pretty big, and I know lots of people who are security guards that are not police officers, but how big is this use of off-duty police and private security? And the answer is it's pretty big. University of Illinois study of 162 responding agencies, 130 of them, that's 80%, permitted at least some form of private off-duty employment. When we say private off-duty employment, that study did not count those who work as landscapers or bartenders or other non-law enforcement or security-related details. This is just for security-type work. It did include bouncers at bars and clubs. It did include, those special details, like I said, in apartment complexes and those types of places where someone wants a police officer in uniform and is willing to pay for it. 80% of agencies, and 162 responding agencies is a pretty good sample, and 80% allowed it. Now, in their study, they extrapolated what they found from that study into other departments and sizes and figure that this is an $1.8 billion industry. And that's roughly equal to the combined revenue of the 4 largest security companies in the United States. So off-duty police make more money from security than the 4 largest security agencies in the U.S. Now, the study was done, I believe, in 2003. There's been considerable consolidation, so I would not go out on a limb and say the total of the 4, but I will say it is larger than the combined revenue of any single security company in the United States. When you talk about the big 3, their profit is not coming in at $1.8 billion, right? There are so many mom and pop small security companies, and police are realistically providing a substantial amount of security in their off-duty status. So it might shock you that 80% of police departments allow this. I mean, if you want your police officers to be alert and you want them to be, never put themselves in harm's way when they're not at work, you want full control over that uniform and that vehicle and that weapon and that badge. Why do you allow it? Well, many of them give the answer that it's good for community relations. You get more police visibility when you have police in these off-duty jobs wearing their uniform and using the department's vehicles. There's financial benefits to the officers, and they really don't want to limit that. If you think about the pay as a police officer, it is not extremely high in the United States or anywhere for that matter. A command officer with a department for a very long time, may be able to pull down some serious money. But the average police officer is, maybe making 60 to 70 with overtime. In fact, I think the average has got quite a bit less than that when you start talking about very small local police departments. Sometimes it's in the collective bargaining agreement. Most police departments are unionized, and oftentimes they will put in their agreement that the department will not in any way impede moonlighting unless they can show, this is pretty common, unless they can show that that particular job is one that reflects poorly upon the department or is a conflict of interest. If you have a bar or nightclub in your jurisdiction that is well known and has had multiple issues with trafficking of drugs, and there's police officers from the department in that jurisdiction who are working the door, that would be a conflict of interest, obviously, in anybody's book. So most of those bargaining agreements will say that, but oftentimes it is outlined in a collective bargaining agreement that you can moonlight. And they cite public demand, and there was the literature, especially that article from the University of Illinois. I didn't find their argument on public demand. I don't know that the public is demanding to have police rather than security some places. I think they just want a presence. But again, if you're going to, take an apartment somewhere that is not extremely, high end and, in an area that's a little bit sketchy, you may want to see a uniformed police officer rather than a security officer there. And so I guess we could call that public demand. But police agencies allow this, and they don't fight back too much against it because many of those in command positions moonlighted during their time. And then we have this new middle ground, and I won't say new because it's really been around for 20 years in some jurisdictions, but it is really starting to catch on simply as a matter of economy and a matter of liability, and that is the special police officer role. Now, special police officers are often employed by private or public access venues. So think about stadiums and museums and shopping malls, things like that. But they're not part of a recognized police force. They normally are in a security type uniform. The badge will be somewhat specialized, and it will say special police or security police in some cases. In Michigan, it's governed by Act 330, specifically Section 338. Security police officers, they can arrest without a warrant, and they can do just as any other licensed peace officer can do. But they can only do it within their venue. So it's very common in casinos, very large hospitals, shopping malls. The venue will apply for a license to employ special security police officers in Michigan. And places like it started really with places like Detroit Receiving Hospital. Detroit Receiving Hospital is really in the heart of the worst area of Detroit, Michigan, and they are, if you ever get shot, no matter where you are in the country, have them fly you to Detroit Receiving because they are specialists. There's no question about it. You talk to any doctor. If they've done any time in Detroit Receiving, they know trauma, right? They are very sought after they spend some internship time there. But oftentimes the reason for gunshot wounds or knife wounds or other types of violence that brought somebody to the hospital brings that violence into the hospital. The hospital wanted a way to have police officers, but Detroit Police Department could not provide people all the time, and so they were the original and pushed for this Act 330, which passed and allowed their security officers to be special police officers and have arrest powers. They carry weapons, they carry handcuffs. If you come in when if somebody's been shot and then somebody tries to come in and finish the job, they will draw down on you, they will shoot you. They have all of the powers of a police officer only within the confines of that hospital. They have no police powers outside of the venue. Now, normally a police officer, even when they leave their jurisdiction, right, if they're following you and you go across the county line, you say, you can't stop me now, Mr. County Sheriff. It doesn't work that way. The pursuit started. They may continue it. They have jurisdiction across a very wide area, whereas a special police officer or security police officer is a very small area. Really common, again, in casinos. The hospital started it, but now it's spread to shopping malls and casinos in the state of Michigan, and we have many of them, especially in the city of Detroit. Now, in Pennsylvania, you have Act 44 of 2018, and it recognizes school police officers. Now, you probably had school resource officers when you went to high school, and normally those were part of and working under a grant, federal grant normally, but they were part of the local sheriff's or police department. Right? The police department got a grant to put somebody in the school who was a school resource officer. Now, school police officers in Pennsylvania are uniformed police officers who are employed by the school districts normally, and they have jurisdiction just as any peace officer does, but only within the confines of that school. And so Pennsylvania is starting to turn that same corner that Michigan has turned. Ohio is starting to turn that corner. There is talk of it in California and New York. And it really is that middle ground where you require a concentration of law enforcement, but only within a particular venue, and the local law enforcement cannot spare people simply to cover that small area of geography when you've got a big city to protect. So they're growing programs, special police officers in that middle ground. And, the case law on their work is not as clear, although we're going to talk about one here in just a second that kind of gives you an idea of where things might go wrong. So you want good security, and police officers are better trained in most people's opinion and probably right in most cases than a security officer would be, specifically from a contracted agency. And so, what could go wrong? If you hire off-duty police, then you should be shielded from things. And the answer is no, you're really not. United States Code 42, Section 1983. It prohibits state officials or other persons acting under the authority granted to them by the state from violating a person's constitutional rights. Now, that statement sounds pretty clear, that when they're acting under the authority granted to them by the state, then they can't violate a person's constitutional rights. And you would think an off-duty police officer isn't acting under the authority granted to them by the state. They're acting in the capacity of a private employee. But there are gray areas. There are always gray areas. And, there are a number of factors we'll talk about that add to those gray areas. And the courts generally look at an aggrieved party's perception in this. And they use something called abductive reasoning. And abductive reasoning is the duck test. And the duck test is called that because of the old saying, if it looks like a duck, swims like a duck, and quacks like a duck, then it is probably a duck. It basically says you can identify somebody by observing their habitual characteristics. Okay, if every day I see you walk into a bar at 6 p.m., I work across the street and I'm sitting in my window across from this bar and I see you walk in at 6 p.m. and I'm a night worker, and I see you leave at 10 p.m. every night and you stagger out and you're falling down, I could probably make the assumption that you are a daily drinker. I think that's pretty clear. Now, I didn't go into the bar and watch you, throw back any shots, but I'm making an assumption based on habitual characteristics. That's the duck test. And generally, the courts look at these cases where an off-duty police officer is acting in a security capacity, and they look at the person that may have been harmed by that police officer's actions, and they look at what their perception was. How did they see them? As a security person or a police person? That's the duck test. And generally, if that officer is in uniform and in a car that says police on it, then quack, quack, that's a duck. That's a police officer. And let's look at a couple of cases that will bring this into light. So the first case we're going to look at this week is one of detention, when someone was detained. And again, according to 42 U.S.C. 1983, any person who experiences the deprivation of any rights, privileges, or immunities secured by the Constitution laws because of the actions of another person acting under color of any statute, ordinance, regulation, custom, or usage of any state may file an action seeking relief against the party that caused the deprivation. Whew, tired reading that. Basically, if a person is deprived of any rights from the Constitution, and the person that deprived their rights was representing the state, or purported to, or was believed to represent the state, then a person can file suit against the person who detained them. And when security people act as though they're the police, then they're more readily considered as acting under the color or custom of regulation, right? So if a security person acts as though they are a police officer or identifies themselves in such a way, then they are acting under the color of law. They don't have the authority, but they are acting as they do. And when they do, and they detain someone, and that person abides by that detention, right, doesn't try to flee because they believed that the person had the authority because of things the person did, then when the person finds out they didn't, that they were illegally detained, they may file a tort action. Which brings us to Stella Romansky. I love the name. Stella Romansky from Detroit, outside Detroit, actually Sterling Heights, Michigan. A 72-year-old woman who, with a group of her friends, took advantage of an ad they saw in the newspaper that said, for $9, we will pick you up in Sterling Heights on a bus, drive you to the Motor City Casino in Detroit, and buy you lunch and drive you back on the bus. So casinos set these up so that they can bring you in so that you will gamble. All they're taking care of is lunch and transportation, but they assume you're going to spend more than that, and they come out ahead. So Stella Romansky and her friends said, let's do this. Let's go to the casino. Now, it's really not that far from Sterling Heights to Detroit. You'd probably be better off driving it, but less hassle. She's 72 years old. I think we've all seen Stella Romansky in one form or another in the casino if we've been to one. Now, Stella played a machine for about an hour or so. She was going to reconvene with her friends for lunch. Excuse me. And she played for about an hour. And she got up, and she was at her favorite machine, as she told the court. And she got up and she walked around a little bit, stretched her legs. And as she walked by, she was playing nickel machines. And in the days past, before everything was automated with paper tickets that you get at a casino. I don't know if you've been in casinos before, but if you get winnings, it comes out on a receipt, and you take the receipt to a machine. It dispenses your cash. There's no coins falling out of the machines anymore. But in 2001, when this case first started, there were tokens that would fall out, regular, monetary tokens. They look like little nickels. And Stella's walking around the casino, and she spots a single nickel in the bottom of a machine that somebody had not picked up. She picked up that nickel, walked back to her favorite machine, put that nickel in the machine and another $20 bill in the machine, and started to play. Within minutes, Stella was surrounded by 4 security officers from the casino who advised her that she had stolen the nickel, that the casino has a policy against something called slot walking, which is a thing. People walk in casinos and just walk around and look for people who have dropped money. And casinos wanting to, keep people out that aren't going to spend money will have a policy. But the security people, who were indeed Act 330 special police hired at the casino, told Stella that she needed to come with them, and they took her to a security room in the back with no windows and surrounded her and started to ask her questions. So they take Stella back to the security office, and they ask her to empty her pockets and her purse, ask her to provide her social security card and driver's license, which she does. She gets photographed. They make photocopies of her documentation. She has winnings of $14.10 owed to her from the machine. That was still the one she walked away from. The casino security officers counted out $14.10 to her to make her whole for the money that was left in the machine when they essentially detained her. And then they took 1 nickel back because that's the nickel she stole. The casino needed that nickel. The special police officer, Officer Brown, identified herself as a police officer at some point, according to Romansky. Brown contended that she did not identify herself in such a way, although inside the casino she technically could have because she was a special police officer. But there was a bit of a discussion in the court as to whether or not she readily identified herself as that. She was not wearing a uniform, although all the other security officers who brought her to that room were. Officer Brown, the special police officer, came into the room not in uniform and questioned and essentially had Miss Romansky sign a piece of paper saying that she would be banned from the casino for theft, and kept all of her documentation on file and escorted her out of the casino. So all kinds of things at issue in this case. Officer Brown, she's licensed as a special police officer. Is that sufficient to insulate her from claims of unlawful detention or false arrest? Is slot walking an actual offense? Now, a police officer will arrest you for violations of law, but slot walking isn't against the law. It is a casino policy. Was she enforcing a law or policy? And was the policy, if it was that, even if it was a policy, was it published in any way? Would you know if you walked by a slot machine and there was a nickel sitting in the bottom of it and you picked it up, would you know that you violated a casino policy? Or, in this case, purported to be a law since the police were involved. Romansky claimed that since these were security people and she was unlawfully detained because there was no violation of law, that her Fourth Amendment rights were violated because they searched her purse, or at least indicated to her that she must comply with the search through color of law, and they seized 5 cents from her, right? For us, we really want to look at our special police officers and off-duty police as security personnel, an enhancement in this case. Would this case have been a problem if these were strictly security people and we're detaining you for violating a policy and we'd like our nickel back? Which, let's not forget that this is all over a 5 cent token. So what did the court say about all this? The court said where private security guards are endowed by law with plenary police powers, such as with the special police, so the security police officers in the state of Michigan, that they are de facto police officers and they qualify as state actors. They are acting under the color of law. Those casino officers definitely acted under the color of law, and law enforcement officers may use certain powers to enforce laws, but they don't enforce policies. Using off-duty police may allow for arming security more easily, but it also may make their actions being under color of law and increase your liability. And that's exactly what happened in this case. The casinos wanted to have a police presence. When laws are violated, they can make quick arrests, turn those people over to someone to transport them to the jail, and they would be well within their rights. Unfortunately, they also used those those special police officers to enforce policy. And they enforced policy in the same way they enforce laws, with detention. And in this case, there wasn't an arrest, but certainly there was a detention and a de facto arrest of sorts, because they passed judgment and banned the person and took all their data and took restitution of 5 cents. So how did this end up? The jury found in Stella Romanski's favor regarding her 1983 claim. And they also found that the defendants, the special police officers and the casino acting as their agent, violated her Fourth Amendment rights to search and seizure. They awarded her $500. They awarded $500 in punitive damages against Officer Brown. So Officer Brown had to pay $500 to Miss Romanski, but they also made the casino pay $875,000 in punitive damages to Stella Romanski. So I would like to say that, that was Stella's lucky nickel, because she, came very close to being a millionaire, because she picked up that nickel and went through, an hour or so of grilling by special police officers at the casino. But as we see here, that using the special police, they acted under color of law, and they detained under color of law, and they had no legal reason to do so because no law was broken. In fact, there was no suspicion of a broken law, only a policy. And in this case, using special police officers backfired on the casino. So what about off-duty police officers? Those officers that security managers hire because they want a police presence for some reason. They want the uniform, the weapon, the badge, and the car to make a statement. Well, we have Groom versus Safeway, which is a case out of Washington State, Western District of Washington. Miss Groom and another customer walked into a Safeway store. They went to the seafood counter. It was in Seattle, and they ordered some prawns. Big, juicy shrimp, right? Good stuff. And the clerk handed Miss Groom the order, and Miss Groom and her, the person who was with her, weren't pushing a shopping cart or carrying a basket. They were just carrying the things that, that they purchased. Not uncommon, right? If you're only going to purchase a few things, you don't get a cart or a basket. And as they were walking around the store, manager had seen Miss Groom and her companion at that counter and saw them buy this bag of prawns. Rather expensive item. I don't know, expensive, probably $30, $40 if you buy good ones, right? Enough for a couple of people. And the manager noticed that Miss Groom was no longer carrying the bag of prawns. He alerted the off-duty police officer that Safeway had hired to be store security. That was Officer Hahn. He was an off-duty Seattle police officer. And he was hired strictly by the store as an off-duty police officer through the police union corporation to provide security at that Safeway store. And he alerted them and said, I saw Miss Groom handed that bag of expensive seafood, and now she's not carrying it around, and I think that she's concealed it somewhere to steal it. So Officer Hahn approached Miss Groom and asked to look in her purse. She refused. She said, no, you're not going to search my purse. And as they say, hijinks ensue, and next thing you know, she's handcuffed, and she's sitting on the floor in the front of the store, awaiting someone to come pick her up to take her to jail. Now, a third friend shows up with a cart and the prawns. there were 3 people in her group, not just Miss Groom and her friend who were seen at the counter. There were actually 3. The third one was pushing a cart around buying other things. And when Miss Groom and the other companion ran into that person as they're walking through the store, she dropped the prawns and other things into the basket, into the cart, and then went about her business. That is why the manager saw her at one point and didn't see her at another with that bag of expensive seafood. Now, Officer Hahn now has her handcuffed because she argued with him and wouldn't submit to a search. He thought he had probable cause. She didn't submit. An argument ensued. She's now handcuffed sitting in front of the store. So, as we know, USC, right, 42 United States Code, Section 1983 prohibits state officials or other persons acting under the authority granted to them by the state from violating a person's constitutional rights. You've heard that before. Ms. Groom filed a Section 1983 lawsuit against Safeway. Now, not against Officer Hahn and not against the Seattle Police Department, not against the store manager in person, but against Safeway. She claimed that she was subjected to an unreasonable detention and search because Safeway failed to train the off-duty police officers in how to deal with customers and how to deal in a retail, non-law enforcement, but security environment. So this is an interesting twist. It wasn't the officer who mistakenly handcuffed her. It wasn't the manager who mistakenly accused her. It was Safeway store that she filed a lawsuit against because they hired off-duty police officers instead of security officers who would have been trained in how to handle a shoplifter differently. Officer Hahn went directly to his police training and handcuffed and detained, right? Where he didn't have actual proof because indeed the crime was not committed. So Ms. Groom filed lawsuit against Safeway. So, what's at issue? Was Hahn operating under color of law and as such subject to Section 1983 of 42 U.S. Code? Was he acting as a police officer or was he acting as a security officer? Is he shielded just because he's not on duty? Right? If he was hired directly by Safeway just for security work and he believed he was doing security work, and he's working for the private employer and the city is not paying him, then is he shielded from Section 1983 because by definition he's not acting under color of law? You would think. By employing off-duty police officers to act as security officers, do businesses expose themselves to liability under Section 1983? This is the big question for us as security professionals and representing a business. When we hire the off-duty police officer, who gets the liability if that officer goes beyond their duties as a security officer and start to act like a police officer? Essentially, the court found, and that second bullet point is the big one to me, that there's a significant relationship between an off-duty officer's conduct and his duties as a police officer, then the officer will be found to have acted under color of law. Now let's take this to its most rudimentary description. I'm asked to direct traffic, and I put my hand up to stop you so that I can get people to go across the street in front of you. If I am in a security uniform, you readily identify me as a security person who is doing it for the safety of those people, and you will generally comply because you're not a jerk, and most people are not jerks when someone tries to stop, even if it's a citizen. When you're driving down the street, if somebody in no uniform is putting their hand up asking you to stop or to slow down, you assume that there is something blocking the road. Could be someone fell, could be a bumper off a car laying there. They're trying to clear something out of your way. You're not going to just blow by them generally because you're smart enough to know that they wouldn't be standing with their hand up if it wasn't for some reason. But when that person is a police officer, you will absolutely comply because you believe them to be acting under color of law. And this was no different. Safeway hired Hahn to act in his capacity as a police officer in the store. Okay, it cloaked itself in the authority of the state, according to the court. If they just wanted store security, they could have hired store security. They hired a police officer to be store security in his uniform to make people believe that he had the authority of the police officer because he was on duty. There was no way for anyone to tell whether he was on or off duty. Now, Groom was originally awarded $750,000. The court reduced this to $50,000 on the appeal because they thought that was a more appropriate punitive damage. But again, she got detained, handcuffed, sat on the floor in the front of a Safeway store for all of an hour, and she got $50,000, and originally was awarded $750,000. These are some really short decision times, short action times. Stella Romansky and Ms. Groom both really were inconvenienced, and certainly their rights were violated, but they were inconvenienced for a short amount of time. And over the years between then and the time the courts made awards, there was certainly discussion that allowed one court to award over $875,000 and another one to award $50,000 and originally award $750,000. Short decision times because no one thought ahead of time, as I said in the beginning, to go through and think about what the repercussions could be. So what do we learn? So if you need to hire off-duty police because you need to have armed people and you need them in a hurry, I'm not saying you should not do that. I have done it myself. I have a direct threat, and that threat involves somebody with a weapon, and it's a credible threat, and I need armed people somewhere fast. I will call a security agency that specializes in off-duty police because I know that those police officers do have good training in the use of firearms, and they would react properly in the event that someone entered the workplace with a firearm to do me harm, right? But the training of police is not the same as the training you give to a security person. And when you try to use a police person as a security person, you oftentimes, any action they take could be perceived under the duck test, right? If it looks like they're acting like a police officer, then they are acting like a police officer according to the court. You have to talk to your security officers about the legal parameters around arrest. Understanding that a security officer that is not well trained may very well try to make breach of peace arrests on your behalf. And this person may not be an off-duty police officer. They may be a pure security officer, but they're well within their right to do that. But then you're in the quagmire of having to go to court to try to prove that this indeed happened. It happened on your grounds. So the best thing to do is to train your security people to observe and report. Use the legal authority of the police only when they call the police. Don't bring the police in before you need to, in my opinion, unless there's an absolute need, like I said, the need for an armed person in a hurry. But other than that, the use of off-duty police is a dangerous thing, and the courts have time and time again used the very perception test, that duck test, to say the police are acting under the color of law. So that's kind of what we learned this week. There are a number of cases in the book that you will look at on off-duty police, because I think this is one of the things we want to drive home, because oftentimes as a young security manager, you may have someone in your chain of command that says, why don't you just call the local police department and have them send somebody here and we'll pay for it. That is where the trouble can begin. So this week, you have a single case brief that's due, and there are no responses due because this week, most of you will be meeting with your teams to talk about strategy and a little practice and just a little organization for week 14. If you have questions about the week 14 meetings, please send those to your team leader. Do not send those to me. The team leaders were hired, if you will, for that reason, and they are very capable, and they are doing all of the scheduling and filtering any questions through to me, just as you would do in the workplace. We will be setting up those times this week very early. In fact, Sunday of this week, I will send my schedule to the team leaders so that they can set those appointments up with you. Please be on time for those meetings. I'm trying to keep them to 1 hour, and that is out of respect for those who may have things going before or after that may be need to join right at, say, 6 p.m. and be out by 7 p.m. because they have other plans and/or commitments. So please be on time. I would prefer that you have your camera on. I will have my camera on for these meetings. I'm not going to make it mandatory because I think that's a privacy issue. However, I would prefer that you have it on. It's easier for us to communicate. You will, however, need to have video available. Don't try to do this on a cell phone because you're going to need to see some of the things that I will put on the screen. So please make sure that you have your video turned on. Whether you have your camera turned on or not is one thing, but definitely have video available so you can see what's going on in the discussion. Case briefs are due at 11:59 p.m. on Sunday. Be on time again for week 14 meetings. If you're late, I will dock you for being late. Period. Because that's just how life works. I will post a short lecture in week 14 on Monday or Sunday night, midnight, Monday morning, 12:01. Before you meet with me with your team, please go through and just look at that very short lecture. It will give you some hints, tricks, expectations that will be helpful to you as individuals. It's nothing that's going to impact what your team's going to do, but I just want you to understand some things about format. So please view that before. Also, in week 14, I will post the final paper parameters. Those of you who had me before know we write a reflection paper at the end of every course, but there are certain questions that you need to answer in that reflection, and I will give you those questions so you can actually get started on week 15's final paper in week 14. But the Dropbox is only going to be open during finals week. When finals week opens, I will open the Dropbox and I will close it promptly at the end of finals week. So just like any other final exam or project that you need to submit, it needs to be submitted then. With that, have a great week, and I will see you next week. Have a great week.